On the 14th of 2024, defendant Duran Evans appeared in the courtroom of Judge Boyd in the 187th District Court of Bexar County in Texas. The underlying charge in Evans' case is assault on a family member by impeding breath, but the hearing captured here is not about the final verdict. Instead, it concerns a mid-trial discovery dispute outside the presence of the jury. The defense is arguing that the complainant's earliest statement to police was captured, at least in part, on body camera footage, but that the clip cuts off and the officer who took that statement was never clearly identified. That matters because early statements are often used to test whether a witness's story changed over time. Under Texas Code of Criminal Procedure Article 39.14a and Article 39.14rh, the state has disclosure obligations regarding offense reports, statements, and information that may be favorable to the accused, including information that could impeach a witness. In other words, if the defense needs that information to challenge credibility fairly, it may have to be disclosed. Here, counsel says the missing officer identity prevented meaningful impeachment. The hearing begins when Judge Boyd asks a direct question: what exactly is the discovery issue?
Yes, what's the discovery issue?
There's a video. The first statement made by the complaining witness when she comes to the police office is recorded, and that was tendered in discovery. I was under the impression that it was one of the officers who made a report. All the officers I have in the police reports, I'm thinking it's one of them. We've subpoenaed them. We can talk to them about it. This morning, I asked for the officers that I thought it was, Ms. Caballero,
Officer Caballero.
asked her, because she wrote the statement that she's the one that met them. So I said, here, will you have her review this 1 minute, 30-second body cam, just so we can.
So what's the issue?
Issue is, she says, well, that's not me. It's these, I think it's these two other guys who were mentioned nowhere in the reports. And in the video, she starts making a statement about what happened to those officers, and then it cuts off. So I don't know who those officers are. I don't know what that statement was. There's no way to really impeach her.
Well, the statement is not going to come in until we have a hearing on it.
Well, my issue is that they've got officers they want to bring who heard a second version, a third version, a fourth version. They're saying that's not us that heard that first version that you saw on video that got cut off.
And they can't talk about that.
But how can they even talk about what she told them? Because I'm not able to impeach any of these witnesses if I don't have all of their statements that the state has. And I don't have the same knowledge that the police department has. Since they took these statements, that first statement might have tons of impeachment in it that I can use against Sanani, that I can use against.
So why is everybody waiting till the last minute to talk about a first statement?
To the state's knowledge, there are no statements that have not been disclosed to defense. Everything has been documented in the report and been provided.
Has the first statement been provided?
Yes.
So is the only issue that there needs to be an officer?
Hold on. What it is, Your Honor, is that the statement was stopped in the middle of the body cam video. The statement's done. So we were anticipating, thinking, because the impression that we got, it was from this one officer who was going to be testifying. So when we go to question her and we were asking her questions, it's basically saying, oh, that's not my body camera. That wasn't me. I don't know what happened at that point.
She didn't know what that statement.
So she doesn't know anything about that statement. So, and the statements have been changing throughout. So we want to see how far the statements have changed from statement number 1 to statement number 2 to statement number 3. If we're just finding out today that that statement number 1 wasn't even taken by the officers who we believed it to be, we can't properly impeach. If they can identify who that officer is, then we can bring them up and testify. Well, what is it that she told you in statement number 1? But we can't even do that because they've not been identified by this person. And as you well know, in investigative processes, any officer that has any contact with the complaining witness and that complaining witness is making statements should, under proper investigatory standards, make a supplemental report so that we can know what's going on. We can't even say that today. So as far as the court's question as to why are we just finding this out right now, we just found out right now. This is not any bad conduct, and I'm not trying to impute any bad conduct on the DA at this point, but my point being is that this is something that should have been brought to our knowledge, and just hiding the ball and saying, well, we didn't think about it, we didn't know about it, that's insufficient. That's denying the client due process.
Here's my question.
What the court has just heard is the defense arguing that it cannot properly impeach the complainant without identifying the officer connected to the earliest recorded statement. Under Texas Code of Criminal Procedure Article 39.14, the prosecution has discovery obligations. Discovery is the process by which the parties exchange evidence before trial so that neither side is unfairly surprised. The defense here is not only asking for a recording, it is also arguing that it needs to know who was present, who heard what, and whether any additional police report should have been created. The term impeachment has a specific meaning. It does not mean insulting a witness. It means challenging the witness's credibility. One common form of impeachment involves a prior inconsistent statement, which is an earlier statement that does not match the witness's later testimony. Here, defense counsel is saying that if the complainant told one officer one version and later told another officer something different, that sequence could matter greatly to the jury's assessment of credibility. This is also why supplemental reports matter. If an officer had contact with the complainant and received a meaningful statement, the absence of documentation can become a serious trial issue, even if no one is alleging deliberate concealment. Judge Boyd now moves from argument to fact-finding and insists on a clearer answer.
At least three.
One statement that they made initially to the officer. What they're referring to, this body cam that they have, there is no audio on this body cam. It cuts off. It's like a minute and something long. It's very short. If Your Honor would like to watch it, see there is no audio on it. Additionally, if the statements were, as I was saying, to Officer Caballero, who is here present to testify, if there's follow-up done by the assigned detective. That was good.
So this is my question, and I want everybody to answer the questions that are being asked. First, is this a statement involving the complainant?
Yes.
All right. So how many statements is the complainant having is attributed to the complainant?
Okay, are we referring to different times when the statement was made?
Just a total. Did this all happen in one sequence?
Of course, it not.
All right. So here's the thing. I need one person at a time. And this is what I want to remind everybody. Proper ruling, if everybody wants to converse over each other, this is the information I need and this is the information I want. And then you can all do your arguments afterwards. So the first statement, and I'll just call it first statement, and that was by the complainant. Who is the officer who took the first statement? All right, I'm gonna have y'all step back. Y'all discuss whatever y'all want to discuss, then you come back. But the jury is coming in like 5 minutes. And if y'all have not finished discussing it, then that means that you all.
Yes.
All right. That's the first statement.
First time she tries to make a statement about this incident.
All right. And then the second statement?
Is when she goes to the police station and meets with Officer Caballero.
No, that's not correct. The second statement was made at the station to some mysterious police officer who had the body camera. And the body camera, as she starts to talk, it goes off. Now, the questions that we have is, what did she tell that officer, and why? And if we had that officer, to ask the officer, why did you feel the need to turn off your body cam?
Is there a statement?
So what is in verification discovery, the video that they have is assigned to Officer Kennedy. Reading on his supplement, if they disagree, to me, it appears he is their live hope response version of like a UED. It's the person that essentially took the photographs, attached them to their, that's what his supplement looks like it reads. But I mean, yes, it looks like when he was taking photographs, statements were given to him, but essentially his purpose of coming to the station was for that. And there may have been statements given to him while he's taking photographs. Is the only body cam exists that is this one that they have, where as soon as potentially audio comes about, it cuts.
And the point that we're making with that particular statement, Your Honor, is that through their own witness and evidence we got so far from discovery, is that there was another officer there, and the Officer Kennedy saying that wasn't my body camera. That was a mysterious person.
We thought it was going to be Officer Kennedy. He's the only other person. Officer Caballero, when I asked her, well, why don't you take a look at this video before Kennedy gets here?
Let me ask you this.
Officer Caballero and Detective Jimenez are here.
All right, bring
Kennedy's,
them down. And they will come down and you all talk to them. All right, thank you.
In this next phase, Judge Boyd does what trial judges often must do during fast-moving disputes: slow everyone down and force the issue into a manageable form. The prosecutor says there were at least 3 statements. Defense counsel says the key problem is the missing identity of the officer tied to the body camera, and the judge repeatedly narrows the question to the one fact she needs in order to make a ruling. This is significant because evidentiary rulings depend on foundation. Foundation is the basic factual groundwork that allows evidence to be admitted or challenged. Without knowing who recorded the video, who heard the statement, and whether the statement was preserved, the court cannot easily decide what remedy is appropriate. Hearsay is an out-of-court statement offered to prove the truth of what it says, but a prior statement may sometimes be used for impeachment rather than for its truth. That distinction often matters in trial, and it appears Judge Boyd is already anticipating that issue. Before ruling on admissibility, the judge allows limited questioning to identify the body cam officer without turning the matter into a full evidentiary examination.
Speaking to the jurors, I won't blame anyone, of course. I will just let them know that there have been technical difficulties. All right. So both the defense and the state are going to speak with you briefly in the back. There is an issue concerning a body cam video and audio. And so there's been some discrepancy over who that might have been. So maybe you all will be able to clear that up for the defense and the state if there's any type of discrepancy. So that's the only thing they're going to ask you about, because now is not the time for people to do direct examination and cross-examination. It's just for them to discover an issue with a body cam. So supposedly, from what they're telling me, there was a body cam with the complainant in this case.
yes.
The audio was cut off, and there's some confusion about whose body cam that belonged to. So you all may be able to clear that up for us. So if you all will talk to them.
This short exchange is easy to overlook, but it is legally important. Judge Boyd is trying to preserve the integrity of the trial by limiting the scope of questioning. In other words, the parties may investigate who owned the body camera, but they are not being allowed to conduct full direct or cross-examination on the merits of the case at that moment. That kind of restraint matters in front of a jury. If courts allowed every discovery problem to become a miniature trial in the middle of proceedings, jurors could be exposed to incomplete or confusing information that has not yet been ruled admissible. The next development is the one that changes the entire dispute.
You're welcome. State versus Duran Evans. Could I have parties announced for the record?
Daniel Diego Sanchez for the state.
Sid Greehey for Mr. Evans.
Yes. So where are we?
So we discussed this with the 2 witnesses, the 2 officers in the back. The female officer gave 2 names. She thought that it might be a Corporal Reese or an Officer Brian Smith. The gentleman officer said that he thinks it sounds like Officer Kennedy. We just found out right now that Officer Kennedy was charged with aggravated assault by a public servant in this courthouse, being prosecuted by this district attorney's office, which we were not made aware of until just right now. He apparently pled out of the 226 on the 1st, which was Monday. He's sentenced for a PSI on the 28th of January. We're just finding this out.
And as far as our ethical obligation, when it comes to this, there's no obligation until the conviction of the officer has been determined, and his conviction will come, it looks like, in January, at which point that would have been the state's responsibility to this, ethical disclosure.
In the spirit of the law and what they should be told that your witness.
Yes, and as soon as we became aware of it, it was disclosed.
I find it hard to believe that this district attorney's office is not aware of a person that they're prosecuting in the courtroom directly underneath this one.
It wasn't disclosed till 30 seconds.
All right. So here's the thing. Number one,
We still don't know who the officer was on the
just
body cam.
1 second. So number one, I do not find it hard to believe that these specific attorneys didn't know someone else was being prosecuted. Now, are they supposed to have constructive knowledge? That's completely different. But as far as them having actual knowledge that he was charged with an offense and that it is in this courthouse, necessarily they wouldn't have an actual knowledge of that. And how many prosecutors, when you're running criminal history, you actually run the criminal history of officers? That's usually never done. So I understand that constructively they should have known, or constructively they do know, but they didn't have actual knowledge. Did you have actual knowledge? Did you have actual knowledge?
Did not.
All right. So he doesn't have actual knowledge, but he has, y'all have any information for me?
Yes.
Yes.
We, as of right now, have no reason to believe that that body cam belongs to any other officer other than Officer Kennedy. Still trying to confirm it through his superiors over at the Live Oak Police Department. But no information has been provided to us that would lead us to believe that it is anyone else but Officer Kennedy.
The revelation concerning Officer Kennedy is the centerpiece of this hearing. Defense counsel reports that Kennedy may be the officer connected to the disputed body camera recording, and then adds a second fact. Kennedy himself was recently charged with aggravated assault by a public servant in the same courthouse, allegedly prosecuted by the same district attorney's office. If Kennedy were to testify, that information could become impeachment material. Under Giglio versus United States, decided in 1972, the prosecution must disclose certain information that could be used to challenge the credibility of a government witness. More broadly, under Brady versus Maryland, decided in 1963, the state must disclose materially favorable evidence to the defense. Judge Boyd then draws an important distinction between actual knowledge and constructive knowledge. Actual knowledge means a person truly knew the fact. Constructive knowledge means the law may treat the person or office as knowing it, even if that individual prosecutor did not personally know it at the time. Here, Judge Boyd says she does not find it hard to believe that these specific attorneys lacked actual knowledge of Kennedy's prosecution. But she also acknowledges that constructive knowledge is a different question. This is significant because the law sometimes looks beyond the personal awareness of the trial prosecutor and considers what the prosecution team, taken more broadly, should be deemed to know. Rather than make a rushed ruling on an incomplete record, Judge Boyd turns to the practical problem. Kennedy is apparently not even under subpoena.
So here's my other thing. So is Officer Kennedy subpoenaed to testify in this case?
He was not subpoenaed by the state. He was not, the state was planning on calling.
I've issued a subpoena.
If needed for him.
All right. So the state is going to want him to be here. So y'all will need to contact Mr. Kennedy's attorney. So I'm going to excuse the jury. They're going to be back here tomorrow, and you all need to be here by 10. And you need to have all the information be ready.
At this point, the court does not force the issue to a premature conclusion. Instead, Judge Boyd excuses the jury and continues the matter until the next day. That may seem anticlimactic, but it is often the most responsible course. A trial judge must protect both efficiency and fairness. When a potentially important witness has not been subpoenaed, and the parties are still trying to identify the source of a disputed recording, a short delay may be preferable to an uninformed ruling that could create reversible error on appeal. The next morning, the court shifts from factual confusion to remedy. In other words, the question becomes not simply what happened, but what the defense is asking the court to do about it.
Sure.
Thank you.
All right. Thank you.
The next morning.
So that the state is imputed to know this information, whether it's actual knowledge or constructive knowledge, or any distinction of today's. That the state was well aware of this. Mr. Kennedy, after has been notified by the state that he's not been subpoenaed and he was expected to subpoena. The answer in my question as to why he's not subpoenaed, so that if we can get a hold of him.
All right. So with regards to the statement that was made to Mr. Kennedy, whether or not that will be excluded, we'll take that up if it is offered. With regards to any other statements that the complainant has made to anyone, that's going to be subject to the rules of evidence. and whatever objections people may have. I'm sure both parties are aware that some statements are out of court statements that are not sworn to. So do you want Mr. Kennedy here?
Everyone here, they stated that they can't get a hold of him. Your Honor, he was in the sport, the state knows how to get a hold of him, absolutely care for pretrial services. To do this.
Okay,
I'm asking the state and asking the court to notify the state.
All right, so here's my question with Mr. Kennedy. Do y'all want him to be excluded from testifying or not? So that's what,
I want him here to testify and I'm subpoena. What I asked the state to do is if they have pretrial services on that say, hey, show up today and you can get served right then and there.
all right, so
And
I don't
know where he lives. I mean,
So my question is, and I want everyone to consider, and I'm bringing the jury in. My question is, everyone needs to make a determination. Do they want him excluded from testifying? Do they want any video where the complainant was speaking to him excluded? You all need to let the court know that, and the court will take that up. But for now, just
By the end of this hearing, Judge Boyd has not entered a final ruling excluding either the statement or Officer Kennedy's testimony. Instead, she makes clear that if the statement to Kennedy is offered, the court will address admissibility at that time under the rules of evidence. She also instructs the parties to decide what remedy they are actually seeking: Kennedy's exclusion, the exclusion of the video, or both. So the immediate outcome is procedural rather than final. If the jury is sent home, the issue is carried forward, and the parties are told to secure Kennedy's presence through subpoena if they want the matter resolved on a complete record. This hearing illustrates a broader principle of criminal procedure. Trial fairness does not depend only on dramatic rulings. It also depends on accurate disclosure, proper documentation, and the court's willingness to slow the process down when critical witness information is missing. In other words, due process often turns on details that may seem technical at first glance. Who took the statement, whether it was documented, whether the defense had a fair chance to investigate it, and whether impeachment material was disclosed in time to be useful. As of the time of writing this episode, the transcript alone does not reveal the final outcome of the Evans case. The later ruling on Kennedy, or whether any appeal followed, those facts will need to be confirmed through the docket and related court records. The larger lesson is straightforward. In a criminal trial, even a 1-minute body camera clip can raise serious questions about credibility, disclosure, and the state's duty to ensure that justice is not only done, but done fairly. Let us know if there is a case or courtroom interaction that you'd like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so that we can help foster a more informed society.